Everything's fine on 93.9 Dublin South FM.
Good afternoon. It's a pleasure to be here again to discuss another important topic related to India. If you recall, in August, we explored the legal system of India as potential enemy of the nation, surprisingly. That discussion was argumentative, but last week we did witness a Supreme Court's judgment on the bulldozers' action in India. Engaging in that discussion with a few intellectuals, it led me to some interesting insights about the origin of bulldozer justice in India. To my surprise, I discovered that bulldozer justice was not just a tool for so-called instant justice. Rather, our society, our Indian society and culture have both numerous mechanisms embedded for delivering such kind of justice. So there have been many instances of instant justice carried out not only by the public, but also by government authorities other than the bulldozer justice. So several key discoveries emerged from these discussions. Before that, we need to differentiate between the principle of natural justice and instant justice. So the natural justice emphasizes on fairness, transparency, and the due process. And this remains still the cornerstone of India's legal system. It is enshrined in our constitution, and we have a huge infrastructure which supports our constitution in order to implement the due legal process. The natural justice refers to the legal philosophy that certain fundamental rights must be upheld to ensure fairness in decision making. And this principle is deeply rooted in the rights to a fair trial, including the rights to be heard, the rights to be part of an impartial tribunal. And overall, these principles must ensure that decisions finally made are based on evidences and are not arbitrary action riddled with biases. So we are blessed in India that the natural justice is constitutionally mandated and has been affirmed by the Supreme Court in numerous judgments all this while. For example, Article 14 of Indian Constitution guarantees equality before law. And it also ensures that no person is denied the opportunity for a fair trial or a due process, a legal process. Therefore, this doctrine of natural justice applies not only to the judicial matters but also in the administrative decisions, and it requires transparency and fairness in public administration. Right to information is one iconic example that the Indians have in order to pursue the doctrine of natural justice. But the concept of instant justice is a growing phenomena in India, particularly as citizens are growing increasingly frustrated with slow pace of formal judicial proceedings. And we have witnessed over the years that extrajudicial actions such as police actions, mob lynching, vigilante justice, and even police encounters, they have become common. So what does that reflect? It actually reflects a deep-seated mistrust of the formal justice system in India. Slowly, it has got ingrained in our national psychology. There is a prevailing belief that mechanism of delivering natural justice is slow and ineffective, whereas the excitement and the immediacy, the urgency of instant justice, that is the winning factor. That appears to be more effective. It appears to be more effective. While everyone values the supremacy of the rule of law, on the other hand, the supremacy of Constitution of India, the visible action, the excitement, and the immediate punishment that instant justice provides, it makes it a clear, outright favorite against the slow, lethargic mechanisms of formal justice system. Briefly, to understand that instant justice is just not new to India. It prevails all across, but like in Philippines, under President Duterte, the war on drugs, alleged drug users and dealers were killed in large numbers by police action. And that's between 2016 and 2022, where thousands of Filipinos were killed without due process under the guise of anti-drug operations. Or earlier in the 80s in South Africa, there was this concept called neck lacing, where during the apartheid rule, mobs used burning tires around the victim's neck, gruesome, and that was to punish the alleged collaborators or criminals. But then what is more important is that the instant justice and the violent use of that justice system is very clearly a reflection of lawlessness, a reflection of mistrust in the constitution. And these methods are often used in places where the governance is weak, it's below par. It does not happen in the developed countries. Overall, the frustration is clear because the Indian judiciary is overburdened. The Supreme Court alone has 80,000 pending cases. That's like 2023 statistics, with only 34 judges. There are millions of cases in India which are pending. The average duration ranges from 2 years to 50 years to seek justice. On one hand, in cases like Nirbhaya, it took 8 years of grueling delays and the process to give punishment to the culprits. The other instance where in 2020, under the allegation of encounter killing, 4 culprits of rape were killed in Hyderabad, and generally the public was at peace with this process. But then, who can forget 1984 Sikh riots, where on their own the public took charge of assassination of Mrs. Gandhi and resorted to violence and killing of innocent Sikhs in India, in very own country. But then we don't have to go far. Traditional justice system like the panchayats and especially the khap panchayats, they have provided justice to resolve community issues, and sometimes in a very controversial way. They have been seen as custodians of local traditions, local communities. Whatever the khap panchayats have been delivering, many a times they have been contrary to the principles of natural justice, and they have often bypassed formal legal channels. Still, there are thousands of khap panchayats and panchayats who are rendering administrative discipline to the villages. We have seen anti-Romeo squads, anti-ragging squads who have taken law in their own hand in order to bring peace and tranquility in the society. When I say anti-Romeo, I am not addressing the love jihad vigilante. That's another anti-social action by the elements of the society. So what we are witnessing is that there is a very fine line between the general behavior of the public, their expectation from their own traditions and customs, and relying simultaneously on the judicial process of the country, relying heavily on the constitution of the country to impart justice. But then, equally, there are failures on both sides. There are schools who punish children in order to bring discipline and learning in the society. But then there are fake encounters by the police in order to create a deterrence to the criminals and the terrorism in this country. The law takes its own journey, as we have seen in Ishrat Jahan case, where the police is implicated, is convicted, and then comes out clean, and then this cycle goes on for another 15-20 years. So it's a mix of methods where the judicial system and the behavior of the society are interplaying and are undecided about the boundaries where they have to rely on each other while also being self-disciplined and law-abiding simultaneously. It's a complex situation. We will continue with our discussion, but for now, the bulldozer justice has come to an end. It had created havoc, and the consequences of bulldozer justice as an example, which could have percolated down further into our society, has been stopped forever. And that's the good news. Thank you for patient listening this week also. Appreciate your feedback. See you again next week. Bye for now.
You are listening to 93.9 Dublin South FM.
Broadcasting from the Dundrum Town Centre. This is Dublin South FM.